Jagger Strang, you can remain seated until I tell you to stand. I've got to sentence you for 2 offences of possession of an explosive substance, 2 offences of collecting information capable of being of use to a terrorist, 1 offence of possessing a blowpipe, 1 offence of making a threat to kill, and 1 offence of making a threat to destroy or damage property. You pleaded guilty to those offences on the first day of your trial, and you will receive 10% credit for entering those pleas at that stage. You are now 18 years old. These offences were committed in September of last year when you were only 17. I accept that you were, at the time you committed them, an isolated young man. You had the problems at home about which I have read, and you had not properly come to terms with your family's move from your native South Africa to this country some 3 years ago. You wrote in a note to yourself that you were being bullied and that you had developed, quote, a hatred for everything. I take this background into account when I sentence you, along with your good character, your health, the contents of the pre-sentence report and the mitigation advanced to me, the letter that you wrote, and the references I have read about you. Against this background, you developed unhealthy interests, summarised by the probation officer who prepared the report on you as, quote, unhealthy attitude and behaviour towards violence. You became obsessed with serial killers such as Anders Breivik, Jeffrey Dahmer, and the Sandy Hook killer. You researched them, kept articles about them, and even ranked them as to how significant you thought them to be. You wrote what you termed a manifesto, in which you said that you planned to do something big, something violent, maybe serial killing, maybe a rampage. You had also written that you wanted to be like the serial killers in whom you were expressing a deep interest. You told someone online that you worshipped them. Although I accept that you had made no plans to do anything of this nature, you were at times contemplating following in their footsteps. At the same time, you developed an unhealthy interest in explosives. You acquired the chemicals necessary to make both gunpowder and thermite, and you made them. You tested them by causing them to explode. You say that you did this in a safe manner, but you are not a trained chemist. Any amateur experimentation with explosives carries with it the danger that people might get hurt. You experimented with your family in the house. They, at least, were potentially endangered by your actions. At the time of arrest, you were in possession of some gunpowder and thermite, which you had already created, but also sufficient of the base chemicals to make a further 320 grams of gunpowder and 1.3 kilograms of thermite. You had no other use for these base chemicals, and I infer that you intended to pursue your interests by making more of the explosives. Also, in September, you carried out internet research related to your passion. You accessed 2 documents which could have been of use to terrorists. One gave instruction on how to make a detonator, and the other on how to make gunpowder. There is no suggestion by the prosecution that you planned to take any step towards making those videos more available to terrorists, but it remains illegal for you to have accessed and possessed them. Your offending came to the attention of the authorities when you told classmates at Stafford College that you idolised serial killers and that you wanted to acquire a pressure cooker so that you could make a bomb using explosives and shrapnel, which you would then blow up your college with. Although it has been accepted that you had no such intention, you persuaded those to whom you spoke that you intended to make good on your threats. You said, for example, that you had identified a particular classroom to blow up because of the number of glass windows it had, and that you had worked out an escape route from yourself from the classroom to the college exit. When one of the group in which you confided sought proof that you were serious in your planning, you provided that proof by sending him images of homemade weapons, videos of you igniting substances in the kitchen and garden of your home, and videos and images of serial killers. Their concern was such that they reported you to teachers at school the next morning. Your classes were cancelled, the police were called, and you were arrested. Your guilty pleas were entered on the basis that you had no intention of building a bomb. The prosecution accepted that basis, and therefore that is the basis on which I sentence you. It follows that I must also sentence you on the basis that you had no intention of carrying out your threats to kill and damage property. And so I turn to sentence. In determining the proper sentence in your case, I have considered the Sentencing Council definitive guideline on sentencing young people, totality, the relevant offence-specific guidelines, and where no offence-specific guideline exists, the general guideline. I take into account the guideline on sentencing young people because although you are now 18 and were 18 at the time you pleaded guilty, you were only 17 at the time of the offending, and maturity does not suddenly arrive at the moment of one's 18th birthday. I have concluded that no sentence other than a custodial sentence could be justified for your offending. That is because of the seriousness and number of the offences you committed. There is no specific guideline for possession of explosives, so I fix your sentence by considering the maximum term for the offence, which is 14 years, the relevant Court of Appeal guidance, which in my judgment is to be found in the Queen against Harvey, and the Sentencing Council guideline for the closest offence, which I have concluded is the guideline for possession of a prohibited firearm. The explosives you possessed are akin to prohibited weapons, which, like firearms, are capable of killing and injuring people if misused. Considering the guidance in Harvey, I consider firstly the motivation for your offending. I accept that it was curiosity, but it was curiosity fueled by an interest in killers and killing. It was not simply an academic interest in chemistry. Second, I consider the potential harm. You experimented in your own home and thereby put yourself and your family at risk. It is of significance that you had the base chemicals to make more of each type of explosive. The longer-term potential for harm lies in the possibility that your obsession for explosives and serial killing would align. Third, I must consider what the Court of Appeal called in Harvey the strong need for deterrence. It is easier now than ever before for people with interests such as yours to find instructions for making explosives on the internet and then to buy through the internet the chemicals necessary for making such explosives. Gunpowder and thermite are not toys. They are akin to dangerous weapons. Those who act as you did must be clear that they will receive custodial sentences should they do so. Then, using category B2 in the guideline for possession of a prohibited firearm as a guide, I conclude that had you been an adult when you committed these offences, without the mitigation that you have available to you, I should have sentenced you to 6 years' imprisonment, less credit for your guilty pleas. Your youth and mitigation means that I should significantly reduce this. Someone of your age is to be taken as being more capable of changing the course of their life than somebody who is older. Therefore, your sentence on each of these offences will be one of 3.5 years in a young offender institution, less 10% credit for guilty plea, which equates to a sentence of 37 months. Those sentences will run concurrently with each other. The length of the appropriate sentence does not allow me even to consider passing an extended sentence on you. The sentences for collecting information of use to a terrorist will also run concurrently with those terms. They do not represent separate criminality. They relate to the internet resources you accessed to make and test the explosives. They fall into Category C of the relevant guideline. Category C because there was no terrorist connection to your activity, and harm Category 3 because the articles contained no instruction relevant to a particular specific terrorist act. The starting point for sentence is 12 months. Your youth and other mitigation allow me to reduce that to 10 months, and from there further to 9 months in order to reflect your guilty pleas. These offences automatically make you an offender of particular concern. I must therefore order that you will serve an additional 12 months on licence after your release from this part of your sentence. The sentence will therefore be a sentence of 21 months, comprising a custodial term of 9 months and a 12 months extended supervision period. The threats that you made to your college associates do represent a different strand of criminality and will attract a consecutive sentence. The offence of making a threat to kill falls into Category 2A of that guideline. Category 2 harm because there is evidence that one of those at least who heard your threats was caused some distress. Category A culpability because the threats were made to children, that is 3 youths aged 17. The starting point for an adult in those circumstances is 2 years. In order to reflect your youth and mitigation, and to ensure that your total sentence is not excessive or disproportionate, I reduce that to 12 months before applying a discount for guilty plea. The final sentence for that count, therefore, will be one of 10 months in a young offender institution to be served consecutively to the 37 months I have already imposed. The threat to damage property was part of the same offending. You will receive a concurrent sentence for that. Based on the relevant guideline and applying the appropriate discount for age, plea and mitigation, the sentence will be one of 2 months in a young offender institution. Although the possession of the blowpipe represents a separate strand of offending, I pass a concurrent term of 2 months for that, so that your overall sentence is not excessive. Jagger Strang, will you now stand up? I sentence you as follows. On counts 1 and 2, 2 terms of 37 months in a young offender institution. On counts 3 and 4, 21 months, comprising a custodial term of 9 months in a young offender institution and a 12-month extension to supervision. All of those sentences will run concurrently with each other. On count 5, a consecutive sentence of 10 months in a young offender institution. On count 6, a concurrent sentence of 2 months, and for possession of the blowpipe, a further concurrent sentence of 2 months. Your total sentence is therefore one of 47 months, or 3 years and 9 months. You will spend up to 40% of that sentence in custody and then be released on licence. Any breach of your licence conditions can result in your being recalled to prison to spend the remainder of your sentence in custody. The time you have spent on custody on remand counts towards that sentence. I stress for you and others that this is a much shorter sentence than I would have passed had you been an adult when you offended, or had you not offered a basis of plea accepted by the prosecution that you did not intend to use the explosives to create a bomb or to blow up your place of education. The surcharge applies and the order must be drawn up appropriately. You will be subject to the terrorist notification requirements for 10 years. This will allow the authorities to keep track of you over that time in order to ensure that you do not offend again. I finally make a forfeiture order in respect of all of the property in the schedule served on this court by the prosecution. That concludes this hearing, and you can take him down.